Welcome to the deep dive. We take that dense stack of research, the legal filings, all those reports you send us, and we really try to boil it down into the knowledge you need. Today, wow, we have quite the dual stack. Two really explosive legal situations unfolding. We're going deep into the, let's say, tactical and procedural side of things. First up, that ongoing FBI investigation into the alleged Charlie Kirk assassination. There are some significant new leads focusing particularly on accomplices, and then completely different arena, well, the legal chaos after the Karen Reed acquittal. It's like a civil war of counterclaims in Massachusetts, really pushing some boundaries.
That's right. That's the mission today. We're looking at two very distinct legal paths. One is this meticulous federal investigation looking for co-conspirators, hidden details, the logistics. The other is this incredibly aggressive civil case. It's less about the original event, maybe, and more about using these powerful legal tools, like intentional infliction of emotional distress, civil conspiracy, trying to completely reshape the story. So yeah, we're tracking the patterns, the motivations, and crucially, the sort of procedural fallout, what actually matters here.
Okay, let's start with the Kirk investigation then. The sources really emphasize the FBI isn't easing up. Director Kash Patel is committed to an exhaustive probe. Definitely feels bigger than just the alleged shooter, Tyler Robinson. They're really digging into these other leads, text messages, Discord chats, and interestingly, who was visiting Robinson's place beforehand.
Right. And what's really jumping out, especially from the analysis by former FBI agent Steve Moore, it's these text messages. The ones between Robinson and his roommate/romantic partner. Moore thinks these are, well, perhaps the strongest sign of an accomplice right now. You've got Robinson texting about being worried about fingerprints, having to leave it in a bush where I changed outfits, and the specific line about worrying what his old man would do if I didn't bring back Grandpa's rifle.
Okay, but couldn't that just be panic? You do something horrific, you're freaking out, you text someone close to you. How does Moore say that proves planning with that person?
That's the million-dollar question, isn't it? Moore's point hinges on the context. He argues that the way they talk about Grandpa's rifle, there's no explanation needed. It's not like, hey, remember that rifle I mentioned? It's just Grandpa's rifle. Moore's take is that this implies the partner was already fully aware, elbow deep is the phrase he used, knew about the gun, its significance, before the event.
So no need to explain which rifle or why it matters?
Well, exactly. And Moore's pretty blunt about it. He says he'd need really strong evidence to convince him this person wasn't an accomplice. He sees indictment as a, quote, strong possibility.
And tying into that idea of planning, not just panic, is the weapon itself. The sources detail this decades-old, untraceable bolt-action rifle, like a World War relic, maybe, made before serial numbers were even required.
Yeah, and that connects directly back to the texts, right? Robinson literally wrote, I don't know if it has a serial number, but it wouldn't trace to me. That just screams premeditation. He didn't grab a modern gun. He seems to have specifically chosen something like, maybe a Mauser 98, maybe an SKS, because it was off the books. No paper trail, wouldn't pop up in any database, makes the FBI's job way harder.
They're also still focused on the logistics, like how did the weapon physically get up onto that roof?
Right, this is classic FBI work. A plus B must equal C. If Robinson acted alone, how did he manage to get this, probably pretty bulky old rifle up to that high vantage point without help? If they can't figure out a plausible way he did it alone, they have to consider other options. Was it planted the day before? Did someone toss it up to him? It forces them to actively rule out the accomplice theory.
We also saw mentions of hand gestures potentially being signals, and this focus on visitors to Robinson's home.
Moore seems a bit skeptical about the hand gestures, but acknowledges they have to check everything. The visitors, though, that feels more serious. Sources suggest the FBI is trying to figure out who Robinson might have met with. Could it be, extreme violent radicals he connected with online? That opens up a whole other can of worms about wider involvement.
Okay, before we switch gears, we should probably address that plane theory that was flying around online, the one about the transponder turning off.
Yeah, the FBI looked into that, talked to the FAA, the pilot. Turns out it was basically a non-story. Just incomplete flight tracking data in a rural area. Happens sometimes. Nothing suspicious there.
Good to clarify. And it's also worth noting, amidst all this, the statement from Charlie Kirk's widow, Erica, expressing forgiveness, not pushing for the death penalty. Moore called that incredibly noble.
Absolutely. A remarkable show of grace in an unimaginable situation.
All right, let's pivot now. Completely different world. From that federal investigation to the procedural chaos in Massachusetts following the Karen Reed acquittal. She's acquitted criminally, but bam, immediately hit with a wrongful death civil lawsuit from the O'Keefe family, John O'Keefe's parents, his brother Paul, his niece Kaylee.
And this is exactly why these things often end up in civil court. The huge difference, the absolute game changer, is the burden of proof. Criminal court needs beyond a reasonable doubt, almost certainty. Civil court just needs a preponderance of the evidence.
Meaning, more likely than not.
Exactly, 51%. If the jury thinks it's just slightly more likely than not that she's responsible, the plaintiffs win. Legally speaking, it's a much lower bar to clear. An easier case, as some experts put it.
And the O'Keefe family's lawsuit isn't just straightforward wrongful death alleging she hit him with the SUV.
Yeah.
They're also suing 2 bars for over-serving her.
Mm.
But the really aggressive part seems to be this claim for intentional infliction of emotional distress. IAD.
Here, IID is a powerful and frankly pretty aggressive legal claim. It's not easy to prove, but when it hits hard. You need 2 things. 1, the defendant's conduct has to be extreme and outrageous.
Okay.
And 2, that conduct must have caused severe emotional distress. And interestingly, the O'Keefe complaint focuses heavily on Reed's actions after the incident.
Right. The sources point to that moment with O'Keefe's niece, Kaylee. She's 14, already lost her parents, and Reed allegedly wakes her up frantically asking, "Did I hit him?"
Precisely. That specific allegation seems designed squarely to meet that extreme and outrageous standard, targeting a vulnerable child. But the IAED claim goes even further. It directly attacks the defense strategy used during the criminal trial. It alleges Reed started this, quote, calculated and malicious campaign of disinformation using that blogger, Turtle Boy.
Including looking things like autopsy photos.
Allegedly, yes. That's part of the claim. All of this is used to argue that Reed's behavior after O'Keefe's death was itself a tort, a civil wrong, causing the family severe distress. It's a very pointed attack.
Okay, so that's the plaintiff's side. But then Reed's team pulls this surprise move. They don't just defend, they go on offense, trying to add 10 new parties to the lawsuit.
Yeah, it's a massive escalation. They're trying to drag in the state police investigators, Lieutenant Tully, Sergeant Buchanan, Michael Proctor, plus the town of Canton itself.
And all the people who were inside the house that night.
Everyone. Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Brian Higgins, all of them.
What's the legal basis for adding all these people? How can they do that?
The argument is civil conspiracy and violation of Reed's civil rights. Essentially, they're claiming all these people, police, town officials, witnesses, secretly worked together. They allegedly formed a common plan to make sure the investigation only looked at Reed and, quote, conspired to ensure that what happened in the house was not explored.
Wow, so this stops being just a wrongful death suit and becomes, I don't know, a multi-front war.
Pretty much. The judge even called it a potential behemoth, warning it could drag on for years, maybe until 2027. He's pushing for settlement, understandably. This strategy, while definitely risky for Reed, does a couple of things. It brings in the deeper pockets of the state police and the town, potentially for settlement leverage. And crucially, it puts those civilian witnesses, the Alberts, McCabe's, Higgins, in the hot seat. Now they need lawyers. They face potential liability.
Which could make them less willing to cooperate in the main lawsuit against Reed if they're worried about her suing them back.
Exactly. That's the potential chilling effect. If you're a witness who talked to the police and now the person you testified about is suing you for conspiracy, well, it might make future witnesses think twice about coming forward in controversial cases. It's a powerful tactic, even if it looks pretty aggressive.
And this web is so tangled, it's actually spilling over and causing problems in other related cases. Specifically, the case involving Aidan Kearney, the Turtle Boy blogger, who was such a big part of Reed's public defense narrative. This part gets complicated.
Yeah, this is where the procedural fallout really gets messy. It's a perfect example of a legal tangle. So the special prosecutor handling Turney's case, a guy named Cosgrove, he's withdrawing, he's stepping down.
Why?
Because the main witness against Kearney, the alleged victim in that case, Lindsay Gaetani, well, she is now suing Prosecutor Cosgrove himself, and also Detective Tully from the Reed case.
Wait, the prosecutor's own key witness is suing him personally? How does that even work?
It creates what lawyers call an irreconcilable conflict. It's a huge ethical and practical problem. Think about it. Cosgrove's job, his duty, is to prosecute Kearney. To do that, he needs to rely on Gaetani's testimony, present her as credible.
Right.
But personally, now that she's suing him, his interest is to defend himself. And how do you usually defend yourself in a lawsuit? Often by showing the person suing you is not credible, that their claims are baseless.
So he can't do both. He can't vouch for her credibility in one court while simultaneously attacking it in another.
Precisely. It's a direct conflict of interest.
Hmm.
The defense argued, successfully it seems, that this conflict completely taints the prosecution. Cosgrove basically had no choice but to withdraw.
That is just a spectacular implosion of a case. And there's history here too, right, between Gitani, Kearney, and the judge who's now handling the big civil trial.
Absolutely. The sources point out that this same civil trial judge, Judge O'Shea, actually denied Gaetani a harassment prevention order against Kearney way back in 2020. Apparently, part of her claim back then involved some alleged social media threat, something about burn everything to the ground, which Kearney's team claimed Gaetani posted herself using some hidden account.
So this fighting has been going on for years between these peripheral figures.
Exactly. It just shows how deep these conflicts run, feeding into this massive legal snarl we see today.
And now, because Cosgrove had to step down due to this conflict, the court can't easily find someone else to take over Kearney's prosecution.
It sounds like it's proving very difficult. The situation is, quote, not conducive to attracting a new special prosecutor. I mean, who would want to step into that mess? You're inheriting a case where the star witness is suing your predecessor, the previous investigation might be compromised. It's like trying to clean up a toxic spill, a real poisoned well situation. It shows how these interconnected fights can almost self-destruct.
So when you step back from all this detail, what's the big picture here for the listener? What ties these two very different, very complex situations together?
I think in both cases, Kirk and Reed were seeing the path of justice being shaped less by the, headline facts and more by the relentless digging into side issues and these really extreme procedural tactics. In the Kirk case, it's all about the untraceable gun, the texts, the logistics, trying to find that thread that points to an accomplice. In the Reed case, it's the weaponization of civil claims like IIED against the defense narrative itself and these massive civil conspiracy countersuits against police and witnesses. The legal system is really being pushed, maybe even strained, by strategies it wasn't necessarily built for.
That really crystallizes it. Okay, so here's the final thought to leave everyone with. In the Reed case, you have that dramatically lower burden of proof, just 51%, more likely than not. You have the acquittal in the criminal case, meaning reasonable doubt already existed. But now you add in these incredibly aggressive civil tactics, IIED, targeting the defense, civil conspiracy claims against practically everyone involved. How does all that influence a civil jury? When the standard is lower, but the legal battlefield has become this complex war zone, what does justice even look like then?
That's the question, isn't it? How does a jury navigate that when the goalposts have shifted so dramatically?
That's something to definitely think about. Thanks for breaking down all that complexity for us.
My pleasure. Thank you for listening tonight. Be sure to follow us on our Facebook page and on DLive at www.dlive.tv/SYMradio. You can find all our social media links in the description below this video. God bless you all. Stay safe, and we look forward to seeing you in the next video. Take care, everyone.